Good morning, everyone. Hope everyone had a great weekend. It was a little chillier than we were anticipating or prepared for, but unfortunately, we're a little sad about the Bengals. It was exciting a few weeks ago when they won. Well, today's Monday, November 3rd. Welcome to the First District Court of Appeals. We have 4 cases on the docket this morning. 2 of the cases have submitted on the briefs. 2 of them will be arguing this morning. So the first 2 that I will be calling out have submitted on the briefs. The first one is case number C250454, In Re EJ. The next case is case number C250283, In Re AH and JW. And then for the next 2 cases, if attorneys can please identify themselves and their readiness to proceed. So the next case is the first case that we'll be arguing this morning, C250260, State of Ohio versus Antone Taylor.
Good morning, Your Honor. Sarah Nelson, appellee, ready to proceed.
Good morning.
Amber Daniel, appellant, ready to proceed.
Thank you. And then the last case is case number C250006, State of Ohio versus Patrick Kembade.
Candace Creer on behalf of the State of Ohio, and I'd like to extend a warm welcome to Wilhelm Park, who is joining us from Germany. He's an attorney.
Okay, thank you. Welcome.
Your Honor, Iris Rodriguez for Mr. Patrick Kembade.
Okay, and I understand that you're going to, are you an intern, is that right?
Yes.
Okay, and so you have, who's with you this morning?
Attorney Andrew Collins.
Okay, wonderful. Okay, thank you. And of course, both of you will be coming up to be seated when it's time, okay?
Yes.
All right, thank you. All righty, so, and by the way, how close was I with the pronunciation of the surname?
Pretty close. Kembade.
Kayambadi. Okay, thank you. Thanks for getting me on the right path there. All right, so, State of Ohio versus Taylor.
And I would like to reserve 5 minutes.
All right. Whenever you're ready.
Thank you. Good morning. May it please the court. My name is Amber Daniel Jeffrey, and I am representing the city of Cincinnati. I will give a brief statement of facts, as this is mostly not factually related. It's mostly related to the motion to dismiss. A brief statement of facts is there are 4 separate prosecuting witnesses. They do not know each other. They were walking in the same general vicinity or the same general area, which is a neighborhood in Pleasant Ridge. As they were walking in 4 different scenarios, a couple of them were walking their dogs, a couple of them were just walking for leisure. Defendant grabs the buttocks of all of them and makes lewd comments to them. A brief history of this case is there were several motions to suppress, several motions to dismiss on this matter, 2 motions to suppress, a motion to dismiss. The first motion to dismiss was in February of 2025. The second motion to dismiss, which is why we are here today, was in April of 2025.
And that's the speedy trial issue then?
Yes, Your Honor,
Okay.
that is. There were felony charges filed on this. They were entirely unrelated. They were filed a year after the sexual imposition. He was locked up on the felony charges and had a bond revocation for the misdemeanor charges.
What was the bond amount in the misdemeanor case?
The misdemeanor case, at first, I am not 100% positive on that. I know that he did post his initial bond that was filed, and then the second bond, I'm not entirely positive what it was. It was a cash bond, but I cannot remember the exact amount on it. But I do know he posted the original bond that was set in 2023.
And then the second bond, why did the bond change?
So his bond went up when he was locked up on the felony. They did a bond revocation for the misdemeanor. The misdemeanor was around for about a year before he received the felony charges. So they had a bond revocation for the misdemeanor charges. And so his bond went up from what was originally posted to a higher bond. And then the state filed a motion for an OR bond, as there's only 60 days on each one of the sexual imposition charges. And at that point, he had served I think about 35 days. By the time that it was actually reduced to an OR bond, it was 44 days.
And the reason the state filed for a reduction is in part, at least, because the state understood that he would be held on the felony bond.
Yes, Your Honor.
Was the felony case at all related to the misdemeanor case?
The felony case was not related in any way to the misdemeanor case, totally separate victims.
Go ahead.
So what happened in this matter is date of arrest was 12/23 of 2023. Date of release for that when he posted his original bond was 12/28 of 2023. There were 5 days served at that point. He was arrested on the new charge on 7/10 of 2024, had the bond revocation. He was released or given the OR bond that went into effect when the judge signed his sheet and gave his order on 8/23 of 2024. 44 days were served at that point, so 49 days in total, 11 days left on each charge. The state filed this motion for OR bond as there were still numerous motions that the defense had filed at that point that still needed to be heard. At the actual argument for the motion to dismiss, the state did say that we had talked to all 4 of the prosecuting witnesses, and if it needed to be tried within the week, we were prepared to go forward and try it within the week. At that point, the judge determined that he was going to do an OR bond, and the OR bond was put on the judge's sheet and went into effect on 8/23 of 2024. Mr. Taylor?
In the absence of the felony bond, would the state have made the motion for the OR bond?
So in absence of the felony bond, I do not believe he would have been held as he wouldn't have had a bond revocation hearing. So there wouldn't have been a revocation because he had originally posted his original bond. So the only reason for the bond revocation was because of the felony.
So the bond revocation, the net effect of that is that he's now entitled to the money that he had posted, but it really doesn't change any custodial action because he was free to leave regardless of the OR bond.
Yes, Your Honor.
Okay.
He would have been free to leave whenever, which was evident by the fact that when his felony was resolved and he was let go on his felony, he was also released on his misdemeanor, and he
Okay.
was released at that
So
point.
the fact that the OR bond really has no real effect on his custodial situation, how does that calculate into what we're here, into the calculus of the speedy trial?
So the state's argument is that once he had his OR bond, his time stopped counting at that point. The judge saw it differently. What he saw is that it didn't go into effect.
We know
until
how the
his-
judge, but
Yes.
just go ahead and answer, because you're starting to run out of time, so
Oh,
just,
I'm sorry. But yes, our argument is that it didn't.
but why?
Why didn't it? Because as soon as the judge put it into effect, that there was an OR bond and he would have been able to get out at any moment. So there wouldn't have been any more time that would have counted at that point.
Okay. And I have sort of an off-the-wall question here.
Yes.
The charge that he was charged with, if he had been adjudicated on it, or ultimately, it would have carried with it the imposition of sexual offender registration, right?
Yes, Your Honor.
That would have been part of the outcome of the case. The fact that it has that, does that have any effect on the calculus of what it's in front of us with the speedy trial?
I do not believe it does have any effect on the calculus of that, since they are totally separate matters. I believe it wouldn't have had any effect on the calculus of that.
Okay.
And briefly, as to our second argument, the state did file a motion to strike.
Okay, I'm going to actually, since I know you're running low on time, I'm
Yes.
just going to ask you a question about that.
Yes.
So in your brief, you assert that the trial court abuses its discretion when it grants a motion based on the same grounds. I have seen case after case after case where a trial court has changed its mind on an interlocutory order. Why is this different?
So I think that this is different because it's the exact same scenario as it was before.
But I've seen that as well. So do you have any authority whatsoever backing up that assertion?
No, Your Honor. We
Thank
do
you.
not have any case law authority.
Thank you.
But we do believe because of the motion to strike, so with the motion to strike, what we do believe on that is that same facts were available at the initial motion as were available at the second motion. They did bring in someone to testify at the second motion. They could have brought that person into the first motion as that was the same everything that was available at this second motion would have been available at the prior motion.
But the trial court has the ability to change its mind.
The trial court does have the ability to change its
Okay,
mind.
so it's not an abuse of discretion then? If the trial court is permitted to change its mind, it's not an abuse of discretion? Would you agree with me?
Yes, Your Honor, in some ways. The only thing that differs in this is that this was filed on Friday afternoon with the motion going forward on Monday morning. The state was unable to respond to the motion in any ways.
Did it ask for a continuance?
We brought it up at the end. The judge did ask if we had anyone to testify. We did bring up that we did not have time to bring anyone in to testify as it was just filed. So we didn't really have a chance.
So was it even set for a hearing? It was just incidental that you were there in court?
It was set for jury, so it was not set for a motion to dismiss hearing. It was set for jury. All of the victims were there. Everyone was there to go forward on a jury. So it wasn't set for motion. The motion was filed on Friday afternoon, kind of at the last minute. So it wasn't really set for a motion to dismiss. It was set for a jury setting.
All right, and so when the city appeared, at that point, it simply argued, well, both sides argued the motion to dismiss, and the city's expectation was that you were going to have a trial that morning?
Yes, the city's expectation is that we were going to go forward on a jury at that point. We did believe that we were going to go forward on a jury, and everyone was present for the jury on that day.
But if the city had wanted to, it could have asked for the opportunity to file a written response and just continue the trial date.
Yes, Your Honor. We could have. The reason that we didn't at that point is because this case has unfortunately gone on for 2 years. So we didn't want to waste any more of the court's time or any more of the victim's time at that point.
So as I understand the facts in this case, the OR bond is set, right? Mr. Taylor doesn't sign it, right? And that's what everything he argues is hinged on, right?
Yes, Your Honor.
Okay, so what is the legal effect of him failing to sign it?
So our argument is that there is no real legal effect of him failing to sign it, that there are other cases. There's not a case that's specifically on point with this. We did do a lot of research and did not find one that was specifically on point with this. But the ones that we did find is where they refused to sign the OR bond. And when they refused to sign the OR bond in those particular instances, that time did not count for them. So the second that the OR bond was imposed, that was when the time clock stopped at that point.
So just to clarify, I read the transcript over the weekend, and it appeared to me that he was definitely present for that hearing and present when the trial court ordered the OR bond.
Yes, Your Honor.
So an OR bond, in essence, is a promise to appear at court. So for an OR bond specifically, wouldn't a signature be required to agree to that promise?
So we do require a signature in Hamilton County. What I would say is that as soon as his felony bond was done, he was able to sign that and get out at that point. We do require a signature in Hamilton County, though, yes.
I'm talking more statutorily. Is the signature required?
That I'm not sure on, Your Honor.
Okay.
And I know we're close to the end of time, but isn't it kind of an illusory, he's not really making a promise. He knows he's going to be held in jail. He knows that he has the felony bond that's going to prevent him from getting out. So how is that a promise? That seems like an illusory promise at best.
Yes, Your Honor, I would agree. He is going to be held on, at that point, the first time that he is able to get out is when the felony is concluded. So at that point, he knew he was going to be held no matter what, as he did have a significant felony bond.
So let me go back to the signature. I'm assuming that the OR bond that he failed to sign is part of the record?
Yes, that is
Okay.
part of the record.
Because I'm trying to figure out if the signature is what effectuates the OR bond, or is the signature confirming that the signatory is now apprised of the information that's contained within that document. And so that has completely different legal effects.
Yes, Your Honor.
And so it seems to me that your argument is that it's more apprising them, right?
Yes.
What's the language in the OR bond that supports that position?
So I do not have that right off the top of my head as to what the language is in the OR bond. Our basis is based on the other cases in which have happened throughout the state of Ohio
But
where.
wouldn't it be specific to that document? Because that document is either a contract, and the signature seals the contract, or that document is not a contract, and it's just simply giving information and advising somebody and apprising them of information.
I believe it's just
So it
giving-
seems to me that what the language is in there can be outcome determinative.
Yes, Your Honor. I believe it's just saying that they're going to come back. I do not believe that it's a contract with the court. I do not have the docket specifically, or the document specifically in front of me. I'm sorry, I should
Yeah.
have brought that with me today.
And I guess the other question would be, the statute that governs the OR bond, what's the language in that, that supports your position that the OR bond is effectuated by the judge, and the judge is the sole authority that effectuates the OR bond? And once that is determined by the judge, we're done. Anything that comes after that is some additional matter like advising of information, but the OR bond is governed by the authority of the bench. So
Yes.
is there language in the statutes that govern the OR bond that would support that position?
Your Honor, I do not know right off the top of my head. I would be able to give you that answer in a moment, though,
Okay.
when I come back for
Okay,
my
I'm
rebuttal.
reserving your 5 minutes, so you're fine, okay?
Thank you.
All right, thank you. Good morning, Attorney Nelson, how are you?
I'm good, thank you.
Long time no see, since
Yes.
Friday, right?
Right, yeah. Much different subject matter this
You
morning.
survived something pretty big on Friday, no, I'm just kidding. We sat next to each other at a CLE on Friday.
Good morning, may it please the court, and good morning opposing counsel, Sarah Nelson again on behalf of the appellee. I want to start today with the threshold issue, explaining to the court that what's at stake here is when is the effective date of the OR bond?
Correct.
Is it the judge's entry, or when the OR bond sheet is signed and therefore put into effect? And it's our position that the signature on the OR bond sheet is what controls when the OR bond goes into effect.
So how does that usually work? Do you, like, my understanding is they usually don't sign the bond until they're actually released from the jail. It's not something that happens in court.
Correct. It's something that's carried out by the Hamilton County Sheriffs at the Justice Center. So the timing of which I am not sure has ever been the subject of case law, but what I think the case law does support, though, is that the signing, when that is signed, is an important fact in when the bond is supposed to be deemed effectuated.
So is that, what you just said, is that true only for OR bonds, or is that true for other bonds as well?
It's true
Like-
for other bonds as well.
Okay, the second bond order, which was in July 2024, was that signed?
No, it was not. But that,
Okay, so here's my question.
yeah.
All right, so you are arguing that the OR bond was not effective because it was not signed, correct?
Correct.
So how then would the July 2024 bond be effective, since it wasn't signed either? Why wouldn't it go back to the original bond?
So when a bond is conditioned on the payment of money, the onus is on the defendant to make that payment in order to put the bond conditions into effect. That's not the same when it comes to an OR bond. The only thing required to put the OR bond into effect is the defendant's signature.
And
So
where is that rooted? Is that rooted in the statute? Is that rooted in the language of the bond? Is it both or the above? Because the case law has to be interpreting something.
Yes, I would say that that's based on the language of the bond sheet, because that's a contract. It's spelling out that you will be released on a recognizance if you pay a certain amount.
So
I
where is
believe-
that rooted in this case in the language of the bond sheet?
I believe in the, I'm going from memory because I don't have the bond sheets in front of me, but I do believe that the terms are the same in all the bond sheets. There's just a blank that's filled out that designates how much is owed. So in an OR bond context, there's a $0 amount. Some nuances, though, between the two. per the statute, I believe, is that, one, I do think that the statute does require a signature under 2937.281. The state challenges that that doesn't apply to own recognizance bond because of the language in .29, but I think those statutes need to be read together because recognizance bonds are just term sheets, so to speak. And because the own recognizance isn't listed in .28, I don't think that means it's excluded. I think that all the statutes should be read together. The language of the bond sheets also, I think, comes from statute, which is in the 30s or 40s in that same subsection, .38 or .40. So we know that all of these terms that come from the statute and that how they're carried out are governed by statute. So the statutory language, I think, is why I rely on the signature in terms of it being important to carry out the OR bond.
How do you deal with the language of the actual statute, 2945.7.3, where it says, at the end of the applicable paragraph, it says, on the pending charge? It
Yes.
seems like this individual, or any individual like this, who's got a felony bond, is not being held on the pending charge. They're being held on a separate matter.
That would be true if the sheriff had carried out and executed the OR bond the day that the trial court's entry went on. And I think that's what's missing here, is that there's a disconnect between when the OR bond goes into effect, which is something that gets carried out by the sheriff's department, which is what the
Well,
clerk.
that seems just administrative. That seems like an administrative error that doesn't really have any substance to it.
It could be administrative error, or it could be, like in the cases that the city cites too, that I refute in their applicability, but there are instances where defendants do refuse to sign these bond sheets, which I don't think is applicable to this case. There's no instance where
But
the
those,
sheriff.
weren't those jail credit cases and not?
They are, but the
So
effective.
isn't that a little bit different because you're dealing with basically someone who's been convicted in a jail credit situation, and this is just the speedy trial?
It is different. I think what's important about those cases, though, is that there was some indication that the defendant refused to sign the bond sheet and therefore did not get the benefit of the lack of signature on that bond sheet, which is completely different from what we have here. If the sheriff had presented my client with the bond sheet and he said, no, I want this time to accrue toward me, for purposes of speedy trial, completely different scenario than the sheriff just doing nothing to effectuate the trial court's order.
Well, how do we know?
That is something that I think the onus was on the state to say, we need a continuance to figure out what exactly happened
Yeah,
in
but a
this case.
continuance would have meant that the 60 days was over anyway.
So if the state's theory is to prevail, that the OR bond went into effect at the time of the trial court's order, then they would still have time, because the OR bond would have been in effect regardless if they asked for a continuance. So I don't think that the continuance would have affected anything in this case. There still would have been a question of when the OR bond went into effect, and if they continue it a couple of days for them to ask, we're still in the same position if the trial court ultimately agreed with the defendant.
So did Mr. Taylor pay the prior bonds? Was the money posted?
The
for the
original
prior
bond was
bonds?
paid by a surety.
Okay.
I can't remember the relationship, but it's paid by somebody else.
Okay, so the prior bond was there's no doubt that that went into effect at that moment, right?
That's correct.
So isn't the real question whether this particular OR bond then superimposes that moment?
Yeah.
Which seems to me would mean that Mr. Taylor or the surety is entitled to the money that was paid, right?
Yes, excellent observation. I
Right?
agree,
So,
and I-
so if that's the case, then at that moment, because when is it that the felony is incurred in comparison to that moment? It's,
I think
when
you're
is he
saying
held,
the
when
bond-
is he held on the felony in comparison to when the surety paid the prior bond?
The initial bond was paid on or around the initial arrest of the misdemeanor on December 23rd. I think it was paid a couple days after than that. That bond was revoked in the felony, based on the felony indictment.
And so in the misdemeanor case, there was no new bond. It was just revoked. He was held without bond on the misdemeanor.
Revoked and a new bond was imposed.
What was the new bond amount?
It was $1,000 at 10% on each case. And as the state alluded to, there were 4 cases in this matter. No new bond was posted at that time.
But then at the same time, the felony bond was being imposed also, and presumably it was much more.
Correct, two bonds in play, neither of which were posted at the second point. But to your question earlier, Judge Zayas, the surety never received,
Well, I think the surety may have to pursue it, so I don't know that I would,
But the surety
because those
did-
are processes that aren't part of the record as to how that works.
so the surety did testify at the motion to dismiss hearing, and when the OR bond was announced by the court, the surety did go and seek to have, at least at that point, I'm not sure if he tried prior to the OR bond going into effect, but he did try to get the initial bond money returned, and he was not permitted.
Well, but doesn't that go back to my concern that it seems that if there's some sort of a flaw with this OR bond, then we go back to what occurred prior to that, and what occurred prior to that is there was a bond, the money was paid, he was free to leave on that bond, but for the pending felony charge, he's being held on the pending felony charge.
He's also being held in a new misdemeanor bond,
But that was never signed. I mean, nobody,
because that wasn't carried out. So in that scenario, that
So
the
when you
onus
say
is
the
on
new, you're
somebody.
talking about the OR, or you're talking about an intervening one?
There is an intervening,
Okay.
after the revocation of the initial bond, there is a new bond imposed. That's the $1,000 at 10% on each of the 4 cases. The state acknowledges that the client was
Okay,
held.
so that one was never signed, if I remember right?
Correct.
Okay, so he has
because-
2 that he doesn't sign, so now we go back to the very first one. The very first one, the money was posted, so if the other 2 were flawed, then don't we go back to that one?
A clarification, if I may, on the lack of signature with respect to a monetary bond. That doesn't necessarily need to be signed by the defendant. It can be signed by the surety that posts the bond. So the lack of signature by the defendant on that bond, I don't think is controlling. It's really the lack of payment.
Okay, so that one wasn't paid, so we go back to the one that was paid, there's no dispute that everything was copacetic on that one, everything was properly executed, everything was fulfilled, including the payment of the money. So if we go back to that and then he picks up a felony, right, then it seems to me that, I think we're
It's-
done. I mean, doesn't that just pause, I mean, that,
And I don't understand the significance of the initial bond once it's revoked. Once it's revoked and the trial court imposes a new bond, that's what takes over.
but you just finished, your whole thing is premised on that new bond is not effectuated.
Because there was no payment towards that bond.
Right.
In a cash bond context, it's significantly different because of the cash payment that needs to be made in
Right.
consideration for the benefit
So we're
of being
still on
released.
so the other one is still in effect because the second one was never paid.
I disagree. The first one is revoked, and the second one is imposed. And the defendant is
Okay.
held on that bond unless and until they pay the new bond, which is the $1,000 at 10%. Now, as the court pointed out, he's already being held on the felony. So we have to make 2 bonds in order to be released on both. It's my understanding that he didn't pay either.
I understand what you're saying.
The
Okay.
state recognizes that, okay, he's being held on this felony in lieu of bond because he has not paid the bond, the new one, as a result of the revocation hearing. Now we need an OR bond to preserve our ability to prosecute this person.
So the cash
Got it.
and the signature are like the defendant's consideration for the contract with the court?
Cash and the signature of the person paying the cash in the context of a cash bond, and then in the context of the OR bond, it's only the defendant's signature that matters. No one else can sign that sheet on his behalf.
so it seems to me like if we focus too much on the administrative procedures that are behind all of this, that's really going to reduce the power of the court to impose an OR bond. Because, I mean, if in this case, a defendant, the sheriff doesn't take the bond to the defendant to sign it, or whatever administrative process is supposed to, I'm not saying this case specifically, I'm just saying in general.
Yeah.
If there is something, if the ball is dropped, if the trial court orders an OR bond, and then, something happens where somehow the defendant doesn't sign it, it just seems like there's a lot of room for getting around what the trial court has ordered without having any sort of consequence.
I appreciate the court's concern in this regard, and it is unclear how long that this procedure may have been going on, because this is the first time in my experience that the lack of signature on an OR bond has been challenged to the extent that it affects speedy trial. But I will say that there are other aspects of speedy trial law where the state has failed to do something, failed to carry out perhaps the service of a warrant over a number of years, and that administrative failure results in a dismissal of the case for speedy trial purposes. So
That
it's
seems a
similar.
little bit different, though.
I think it's similar in the sense that, the trial court in this case made an order, signed a warrant, ordered an OR bond, and there was another entity that's supposed to carry that out to make sure that the state has their ability to prosecute in the way that they want to. And here, the prosecutor is on notice that the court ordered the OR bond. They have the same ability to check the docket for.
But the case
that
law
being
you're
posed.
relying on deals with constitutional speedy trial. And
I
there's a,
believe-
there's a delineation between constitutional and statutory.
Yeah, it seems like in this case, the issues below were all statutory, and the defense didn't really raise a constitutional issue or an equal protection issue.
Correct. My comparison to the constitutional speedy trial rules was just to say that administrative failures happen all the time in this arena, and that the fact that somebody else needed to effectuate or assist the defendant in carrying out the OR bond signature, shouldn't be my client's fault. That's why I think the cases where the failure of the defendant to sign the actual refusal,
Well,
that language
that
is
kind of
important.
is your client's fault, though, is the problem.
But there's no
So-
evidence in this case that he actually refused. If the state had asked sheriffs, hey, did you present this to him when the OR bond was journalized?
So your argument is not that the refusal is what was at default, was what occurred after his refusal, is where the fault lies.
I challenge the premise that he refused anything. I don't think there's evidence in the record that he refused anything. I think he wasn't given the
Understood.
bond sheet to sign until the felony was resolved, which is a problem. He should have been given an opportunity to sign the OR bond sheet when the OR bond was ordered by the court. And the sheriff's failure to have that happen timely should not be counted against my client.
So his so-called refusal to sign, was that argued in the motion before
No, the
the?
refusal to sign language comes from the case law cited by the city.
Okay, so my question is, whether he refused or didn't refuse, was that part of the hearing on the motion to dismiss?
No, the only testimony that came out at the motion to dismiss regarding this process is that it's the sheriffs who carry out signing the OR bonds. So if the state wanted to bring in somebody from the sheriff's department to
So-
ask more specifically about
okay.
the procedure, the onus would have been on them.
So did you argue then that that was waived by the state? By
Oh,
fail-
the
by-
failure?
Yeah.
No, but I did challenge that the factual record in this case doesn't support any indication that my client refused anything. That's my primary argument. The factual
Okay.
record developed below.
But you didn't argue that they waived raising that issue by failing to vet that issue out at the motion?
I did challenge the state's lack of asking for a continuance to suss out some of these, but I didn't argue that there was a waiver in that regard. I'm really just responding to the case law and the use of that language.
We're not finders of fact.
Right, right.
So if this is premised on an element and that element wasn't vetted out down below,
Then I think
then
that
what
that
are we
failure-
supposed to do with that?
Then well, it's mixed review, law and fact in the speedy trial context, and if the decision is supported by the factual record, then you defer to the trial court on that issue.
But there is no factual record because there was no presentation on whether he refused or not.
That's an omission by the state. The factual record that was developed was that the sheriffs are the ones who carry out the OR bond execution, and they did not do so in this case until April, which is when he was released. And that is what the trial court based its decision on. The
Given-
state tries to get around that by citing all of this case law regarding the defendant's refusal to sign, but we don't have that factual circumstance in this case.
Given that it seems like the government's calculus was, he's not going to be able to pay, so we'll just reduce this to an OR, could the defense have raised some sort of equal protection argument below based on wealth disparity? Like he was just, basically they made this decision because they knew he was not going to be able to pay because he had the new felony bond.
The decision to ask for an OR bond, I think, was largely based on not a lack of ability to pay, but because they wanted to preserve the ability to prosecute. And there was a timing stress here because of pending motions. So I know that the defense made some arguments challenging the imposition of an OR bond because there were, no change of circumstances that should have precipitated this other than the state's running out of time. I'm not sure about whether the defense should have argued equal protection of the like, but there was some pushback on actually imposing this OR bond by the defense at the revocation, at the time when the OR bond was being imposed.
All right, I'll give you 10 seconds to wrap up.
Certainly. Just to reiterate, and emphasize that I think a signature is required and important. At the Kitzmiller case cited by the city that I've responded to in my brief, I would just like to point out language from paragraphs 5 and 11, which is, an OR bond would have allowed the defendant to remain free pending trial or other resolution without posting a monetary amount as bail, but required that he sign a bond form guaranteeing his appearance. The case law, I think, is clear that a signature is required.
Okay, thank you.
Good morning again.
Good morning again.
So, an OR bond is governed by RC 2937.29, in that it is defined as a condition under which the individual is released in lieu of bail upon his or her promise to appear and answer a criminal charge. It doesn't specifically say anything about a defendant's signature.
Well, so how do you know that there's a promise? Like, there's nothing in the record indicating his promise. It's just a judicial order, and there's nothing signed that says, this is my promise to return. Isn't that true?
That is true, Your Honor. That is true that there is nothing, he did not specifically promise at the initial hearing that he was going to return to court. So he did not verbally promise in February when the initial hearing was, when that was imposed. Actually, sorry, that initial hearing was back in August of 2024, not in February. February was the initial motion to dismiss. At that initial argument in August of 2024, when the state did bring forward the OR bond, there was an argument from defense that they did not want the OR bond at that point, at which state said that we could have gone forward on the trial within the week. So we could have done all of the motions and been ready to go forward on the trial within the week. So the state was prepared and ready to go forward on the trial and have this case concluded at that point.
But the defense had other motions pending, correct?
The defense did have other motions pending.
And those other motions would have stayed the speedy trial time, correct?
That is correct, Your Honor.
But they would not have stayed the amount of time that he would have been serving on the maximum jail time he could get for a misdemeanor.
That is correct. Yes, so that was our issue at that point, is not necessarily the speedy trial time in the aspect that the state, I believe, only used 1 day of our time with all the motions that were filed. And this time that was extended at that point, it was just his maximum amount of jail time that he could serve, which would have been 60 days, and he had served 49 of those at that actual hearing.
And then he stayed in jail for like an additional 230 days?
He did. He stayed in jail for an additional 231 days as he was being held on the felony, which as soon as the felony was concluded, that same time he was released on the misdemeanor right at that time, which shows to the state that the OR bond was in effect, as he was immediately able to get out of jail. He was not being held on that OR bond. He was being held on the felony bond.
Well, but had he been discharged already by the court by its order in the motion to dismiss?
He had not been discharged by his motion to dismiss, no. The motion to dismiss had not happened yet at that point. He was released before the motion to dismiss hearing, so he did come in, was not held in jail at the motion to dismiss hearing. He was released at that point. So at the actual point of the motion to dismiss, he was out at that point. He was released. So the state's argument, or our main argument, is that if he would have signed the OR bond at that initial setting, that it wouldn't have changed anything, that he would have still been held on that felony, and that as soon as the felony was resolved, he was immediately released, showing that the OR bond was effective when the judge put it in August of 2024. So that would be the state's main argument, and then the state would, if there's no further questions, the state would submit our brief from that point.
Thank you. All right, thank you both for your arguments this morning. We will take the matter under submission, issue a timely decision, and I hope you have a wonderful week.
Thank you.
Good morning. Give me a moment here. I'm stuck. Okay, there we go. Okay. Oh, my goodness, these chairs are very cumbersome. They originate to the remodeling of this court. These are the original chairs that were put in place over 30 years ago. That carpet is the original carpet. So everything in this room is original to when the Board of Education building was repurposed for the county, and the First District Court of Appeals was set up for this floor. So the chairs get a little bit like they're a little difficult to move around. This is my morning workout when I'm on bench trying to move these cumbersome chairs. Okay, so not what you were really here for. You can come on up to the podium. How are you doing, Ms. Rodriguez?
I'm doing well. How are you?
Okay. Good, good, good. So this will give you no favor, but your first name is the same as my mom's.
Oh, awesome. Okay. I don't usually meet irises, so it's always really
I know,
cool.
it's an unusual, it's not like a super, super common
No,
common
it's
name.
not.
So, yeah, that's what my mom's first name is.
Well, good morning, and may
Good
it
morning.
please the court. My name is Iris Rodriguez. I'm a certified legal intern under the supervision of attorney Andrew Paulus. I represent defendant appellant Mr. Patrick Kayambati. May I please reserve 7 minutes for rebuttal?
Absolutely. And you can start when you're ready.
Thank you. Mr. Kayambati is a single father who has been raising 4 children since 2015. He was charged with 2 counts of domestic violence and 2 counts of child endangerment. The jury acquitted Mr. Kayambati on 3 counts and found him guilty of only 1 count of domestic violence. We are here today because the trial court abused their discretion when they excluded evidence of witness bias. Specifically, Mr. Kayambati's testimony demonstrating the complaining witnesses wanted to live with the mother, the more lenient parent.
So I have a question. Let's hypothetically assume that we agree with you.
Yes.
That the trial court abused its discretion by excluding this evidence. The defendant's testimony during trial, he testified that he did strike his daughter with an object. In this case, he testified to it being a Swiffer duster, which, as I understand, is a pole and it has a plastic piece on it. And it's not a zip tie, but I can sort of see why that comparison or that suggestion was made. So he testified himself that he had hit his daughter in the back and that he had struck her with this Swiffer duster. And then the photographs are pretty clear that she has bruising on her arm, which, looking at it, there was no testimony that it wasn't a fresh bruise. Wouldn't that in and of itself be enough to convict him of domestic violence?
No, Your Honor. So the issue that we're dealing with today is the testimony that he was forbidden to bring in because the trial court improperly excluded such evidence.
I understand that.
Okay.
I guess what I'm asking is, okay, let's say that what he admitted to on the stand was hitting his daughter in the back and hitting her with a Swiffer sweeper. And the photograph that was admitted showed bruising. The statute prohibits a person from knowingly causing or attempting to cause physical harm to a family member, and physical harm means any injury regardless of its gravity or duration. She had a bruise. Isn't that enough? His testimony alone, isn't that enough?
That testimony is not enough. Mr. Kayambati has the right to bring in that evidence, and the burden is on the state to demonstrate that Mr. Kayambati allegedly domestically abused the complaining witness, and that's for the jury to decide to look at the evidence in its entirety. But here that wasn't necessarily the case. He was acquitted on 3 of those 4 counts, which would then lead me to our first issue of the evidence that was excluded, because there is potential that had the evidence came in, perhaps the jury could have swayed it the other direction with that last count of domestic violence.
Okay, thank you.
Yes.
So how do you think the other 3 counts, how do you think that weighs in favor of the admission of the evidence that he sought to include? What about the fact that 3 of the counts were unsuccessful? What should that tell the court?
That would demonstrate that had the evidence come in, it would have lead me, because that evidence was excluded, such exclusion was not harmless error, which was argued by the state. Had the evidence come in, Mr. Kayambati could have also been, could have been acquitted off of that domestic violence count. So, moving to the court's abuse of
Let
discretion.
me ask you a question. It's along what you've been asked, but it's a little different.
Yes.
Okay? So, given Mr. Kayambati's testimony, and then given what was excluded, how do those two interplay that there would have been a different outcome?
Yes, Your Honor. So that would lead me to the prosecution's argument of demonstrating that this was not harmless error. But State v. Morris, the Supreme Court of Ohio, has stated that the exclusion of vital evidence would create would prevent the defendant from having a right to a fair trial. So in excluding such vital evidence
So
here.
that goes to error. So.
Yes.
So we're going to presume error.
Okay,
So now really what we're talking about is harmless error.
correct.
So, given the testimony, given what was excluded, how do those interplay that it could have been a different outcome? So how is the evidence that was excluded, how does that give some sort of gloss or something to the testimony of Mr. Kayambati?
Well, had that evidence come in, Mr. Kayambati could have been acquitted on that last count of domestic violence. Because that evidence is vital to his case because it demonstrates impeachment of the complaining witness's motive for wanting to live with the more lenient parent.
But that's impeachment of the witness, but you still have to deal with Mr. Kayambati's testimony.
Correct.
So that's why I'm asking it specific to Mr. Kayambati's testimony.
Yeah, well, such testimony could have come in under, in two ways. So it could have come in under Ohio evidence rule.
But that goes to what is excluded. So what you're talking about is how the excluded evidence could have come in. What I'm talking about is the exclusion of the evidence, how that actually, if it had come in, how that would have affected the outcome.
It would have affected the outcome because it would have demonstrated bias, so it would have attacked the credibility of the complaining witness.
So so is it your position that the bias that it could have demonstrated on the complaining witness would have in some way offset his admission?
Could you rephrase your question? I'm not sure I understand.
Okay. Are you saying that the excluded evidence and the bias that it could have illuminated to the trier of fact on the complaining witness, that somehow also, that somehow would have offset his statements, Mr. Kayambati's statements with regard to the Swiffer?
Your Honor, may I have a quick moment with my colleague?
Are you fine? I know that this is out of. Okay, so I'm going to, if it's okay with, if you don't have an issue with it, I'm going to pause the timer. Do you want to step outside?
No, Your Honor.
I'm fine with you stepping outside. I'm pausing the timer. I'm giving you. As long as you're fine. Okay, I appreciate that.
Okay.
I appreciate you being
Thank you.
understanding. Okay. Again, I'm going to offer, if you want to step outside, you're welcome to step outside. Okay, all righty.
Your Honor, could you ask your question one more time?
Okay. All right. We're going to operate on the premise that it was error to exclude the evidence.
Yes.
Okay?
Okay.
So now we're looking at what's the effect and how it could have changed the outcome, right?
Yes.
And we have a record of, and in the record, there are statements by Mr. Kayambati, right?
Yes.
Okay. So when we're looking at a harmless error analysis, we're going to, as a bench, we're going to take that into consideration, right? So the question then is, how does the excluded evidence play into that?
So it plays into this because with the Swiffer incident on the record, it could have demonstrated that this was actually reasonable parental discipline.
Okay, thank you,
Yes, thank you so much.
thank you.
So,
Do you know, was the mother available to testify, or she didn't testify, right?
I know that she did not testify, but I do not recall whether or not she was offered to testify. So, Mr. Kayambati should be, this court should reverse
Can you do me
and.
a favor, repeat your answer, because I didn't notate it. I
Oh,
want to
no, you're
notate
good.
it.
Yeah, so, based on the record, I know that the mother was not.
No, the answer to my question, I apologize.
Oh,
You
yes,
called-
Your Honor.
Or did you say it was?
It would demonstrate that the Swiffer incident would have demonstrated reasonable parental discipline.
Okay, thank you so much.
Yes. So Mr. Kayambati should be afforded a new trial for the following 3 reasons. First, the trial court abused their discretion when they excluded evidence from Ohio Evidence Rule 616A. Second, on appeal, the state argues that such testimony is inadmissible hearsay. However, under Evidence Rule 8033, such testimony may come in. And finally, while the state additionally argues that such error was harmless, they have failed to meet their burden beyond a reasonable doubt, demonstrating that Mr. Kayambati should be afforded a new trial. So, Ohio Evidence Rule 616A.
Yeah.
Thank you. 616A demonstrates that you may impeach a witness either through extrinsic evidence or through cross-examination. Here, on Volume 3, page 64 of the record, the trial court argued that such evidence could have came in on cross-examination, and because Mr. Kayambati failed to do so, they excluded such evidence. However, they failed to recognize whether such testimony could have come in under direct evidence. And because they failed to consider whether or not this was extrinsic evidence, they have abused their discretion, and therefore, Mr. Kayambati should be afforded a new trial. Thank
All
you.
right, thank you. And you have your 7 minutes reserved.
Thank you.
Good morning. Thanks
morning.
again for your understanding.
No problem. So, and may it please the court, counsel. There's no question that Mr. Kayambati was entitled to use extrinsic evidence to prove evidence of bias and impeach witnesses, but the other rules of evidence are not suspended for that right. I think the appropriate standard review is abuse of discretion. There was some confusion, I guess, in the briefing about the standard of review. And the question before the court is, was there an abuse of discretion? And the question posed to Mr. Kayambati by his attorney was, would it be fair to say that they wanted to live with their mother for some time? And that response would have been speculative. And because the children had already been cross-examined by the defense attorney, there was the opportunity to have that information into the record at that point.
Was there any is it that single question, or was there any other attempt to follow up to demonstrate the potential bias?
There was not any attempt to follow up. It was just a single question. There was an objection by the state. They offered that it would have been speculative, and then defense attorney said it wouldn't be speculative because he knows his children, he has personal knowledge of them. And then the court determined that because the children had been subject to cross-examination and because it would be speculative, that he would not allow it.
But, okay, I believe you're arguing that that would have been hearsay, correct?
Right.
Okay, but if it's not offered for the truth of the matter asserted, if it's offered to show bias, isn't that permissible then? Isn't that an exception to hearsay?
I agree. But I think there is a question of whether or not it would be offered for the truth of the matter asserted or for bias in this case. Because asking, would it be true that they wanted to live with their parent for some time, that requires, honesty in terms of, yes, they did want that to happen. And the actual defense counsel did not argue that it was being used for bias. They said, oh, no, it's not speculative because he knows. So this is the honest truth of the response.
So below, they didn't even argue bias, and they didn't even say, then they didn't even follow up after that one question?
Your Honor, that is my understanding.
Okay.
But do we know why the trial court excluded it?
The trial court excluded that on the basis of being speculative and that the children were subject to cross-examination and they were not asked those questions.
So it could be presumed that the trial court followed the law and understood that it wasn't hearsay, that it went to bias.
I mean, that is an option, but that was not put on the record.
Right, but we're supposed to presume the regularity.
Right.
So we're supposed to presume that the trial court knows the law Not that the
Yes.
trial court got it wrong and thought it was hearsay.
I mean, there's an argument that it would not, no, there is. It would be hearsay, Your Honor. Yeah,
So it is hearsay.
I would say that, yes.
It doesn't go to bias.
I think
I'm just trying to
that-
understand this, really. So don't think like I'm trying to, I really am just trying to understand this.
No, so in terms of what occurred, the question was asked, and he was providing information from his children.
Yeah, I mean, if the
Yes.
trial court says I'm going to exclude it because it's speculative, and the defense responds to speculative, right?
Yes.
And if, you know, and if it's something that can go to bias, again, you know, you know, and the trial court never allowed it to even get to that juncture. You know what I mean? By saying it's speculative whether we're talking about bias or hearsay, right? So it
Right.
never even got to the juncture of whether it's hearsay or bias, it seems to me. I mean, prove me wrong. That is your job there, my question there. You know, I'm just trying to decipher this.
It just wasn't definitively clear from the record whether it went directly to bias or hearsay.
But it never, it seems to me that it never got to that juncture. But, okay. You know, this reminds me a lot of the, of like the self-defense cases. And, you know, there's a lot of academia about the development of self-defense and with the changes of self-defense and all of that stuff, and when things are being excluded, and it goes to state of mind and things like that. And I know this isn't a state of mind situation, but in some ways, I see an overlay there. So I find this very interesting.
So in the reply brief, Kayambati provided authority for the hearsay exception being 8033, but that authority was not provided to the trial court, so they did not have a chance to deal with it at the time. And also I would argue that the then existing mental and emotional physical condition would not necessarily apply to these questions because it says it doesn't include a statement of memory or belief, and the children's beliefs would be at issue, whether they had wanted to live with their mother for some time.
In the cross-examination of the children, was there anything that you would characterize as an attempt to impeach them for bias?
Your Honor, the cross-examination of the children was very brief for both children, and I don't necessarily think that there was an effort to do so. I know with J.K., defense counsel was probably very appreciative of J.K.'s testimony and basically saying, oh, no, my father did not choke me. But yes, no, I would agree. There was very little questioning to bias on either child.
So what exactly is, if we were to decide that it was error to exclude this evidence, what is the state's burden? Or does the state have a burden?
At that point, it would be to say that he was not prejudiced, that Kayambati was not prejudiced by this error, and that is the case here. As you stated earlier, he had testified himself that he had struck his daughter with a Swiffer sweeper. So at that point, he has caused or attempted to cause harm to his child.
Okay. And I think you acknowledged this in the briefing, the burden appears, the state is suggesting that the defendant has the burden to prove prejudice rather than the state having the burden to prove that error was harmless beyond a reasonable doubt.
Yes.
Okay, so basically, if I'm understanding you, what you're saying is that because of Mr. Kayambati's, I hope I'm getting that right, testimony, that it really wouldn't have mattered what the children said, that testimony alone would have been enough to convict him?
I mean, he would need a victim, of course, to say that this occurred, but he himself admitted, I struck my child with the Swiffer sweeper, and it caused harm.
Okay, so then how does this affirmative defense fit into this? as far as if we assume that there was error, and then we're trying to figure out if it was harmless beyond a reasonable doubt. So there was a defense that this was reasonable parental discipline, correct?
Yes.
So how does that fit into this prejudice analysis?
In terms of the case, I would say that Kayambati had more issues than just his testimony. He had his inconsistent statements. He had the fact that he stayed on the record. He couldn't recall harming his children that day. There was body camera footage of Officer Quinn where he admitted using his fists in the altercation with his son, and then when he testified.
Yeah, I was a little unclear about what exactly, I watched it probably 4 times, and I still couldn't figure out. I know he said some fists, but I couldn't figure out if he was talking about both children, one child, or what he was referring
Right,
to.
and while it was unclear if he was discussing both children, it was clear that he was discussing his children, either child, that he used his fists. And I mean in terms of his credibility with the jury. So in his body camera footage, he said, that he used his fists. And then when he got before the jury, he said, I would never strike my child, and he never used fists. So in that way, his credibility had already been impaired by his own testimony and the inconsistencies. There was a choice not to cross-examine the children. I can't speak as to why trial defense counsel did not cross-examine the children on their beliefs or their desires.
I want to go back to this reasonable parental discipline, okay? Does it go towards that? And you're going to say no, right? So please explain.
So in terms of the reasonable parental discipline, so in the jury instructions, it lists that it can't just be anger at an unruly child. And it appeared, even from his own testimony, that his actions towards his children and EK was anger. So his children weren't listening to him. So he had to escalate. They mentioned, or EK mentioned, oh, mommy's going to come pick us up. And then he decides to bring out the Swiffer Sweeper and hit his child. It wasn't that he brought the Swiffer Sweeper out and said, because you failed to take your test, I am going to strike you for parental discipline. It was, oh, you have made me upset. You weren't listening, now I'm getting more upset, I'm going to strike you, which goes to it not being reasonable parental discipline.
Okay, so what you're saying is that the record does not support that it could have been reasonable parental discipline?
Yes, Your Honor.
Okay, thank you.
And the testimony of the children. They are very consistent with each other, that it was over a charger cord, that it was him being assaultive with them and not parental discipline. So I would say that as well.
Okay.
Unless there are any further arguments or questions from the bench, the state will submit.
All right, thank you.
And we'll ask this court to affirm. Thank you.
Okay, thank you.
Your Honors, I would first like to address the speculation issue that the state brought up. So,
Before you get into that,
yes.
how do we look at reasonable parental discipline? What has to be present for us to find that it's reasonable?
Well, that would have been addressed in the jury question, so it should have been made clear there that, it should have been made clear in the jury instructions how to define reasonableness.
Okay, but for our review, how
Yes.
do we determine whether that applies?
Could I get a moment to confirm?
Absolutely.
Thank
Is
you so
that-
much.
and I'll pause the clock with your permission.
That's fine.
Thank you.
Thank you. No, it's, not at all.
May I proceed?
Yes.
Thank you. So reasonableness is up for the jury to decide. And in this instance, this is so fact intense, and we don't have a clear understanding of what reasonableness is.
Okay, thank you.
So addressing the speculation issue that the state has brought up, while that was raised by the state during trial, this, however, is not speculation. It's apparent from the context that this is from personal knowledge of Mr. Kayambati that at some point the complaining witnesses made the statement that they wanted to live with the more lenient parent. And such testimony, we're additionally not arguing that this is not hearsay. This is hearsay, but we're arguing that under Evidence Rule 8033, the then existing mental state, Mr. Kayambati can bring up the declarant's testimony, the complaining witness's testimony of a past conversation that they had that at some point the complaining witnesses wanted to live with the mother. Therefore, while it is hearsay, it's still admissible. And that's,
So it doesn't go to bias, is that what you're saying?
no, it does go to bias, but Mr. Kayambati could have brought such testimony in under the hearsay exception.
Okay, so you're saying that it was admissible on more than one front?
Correct.
Okay.
Yes. And to address the harmless error issue, here, again, the state, in their brief, did not state whether or not they had met their burden beyond a reasonable doubt. Instead, what the state does is they put that burden on Mr. Kayambati, and the more we continue to attack Mr. Kayambati's credibility, the more it becomes prejudicial because he's being excluded to present vital evidence. And as the Ohio Supreme Court has stated in State v. Morris, while the case is not the exact fact, the fact that here we're excluding vital evidence is just as harmless as including 404B.
Just as harmless or
character.
harmful?
Harmful.
That's okay.
I'm sorry, Your Honor.
We knew what you meant.
This is just as harmful as including the 404B evidence that was included in State v. Morris. And because the state has met the burden, Mr. Kayambati should be afforded a new trial. I now open the panel for more questions.
Okay. And if you want to confer before you conclude, I'll give you the allowance to confer before you conclude as well.
Thank you so much, Your
Do you
Honor.
want to? Okay, all right. All right.
Thank you.
All right. All right, thank you. Thank you both for your arguments this morning. We'll take the matter under submission, issue a timely decision. So, Ms. Rodriguez, did you bring a posse with you today?
I did.
Okay. So is that your dad?
Dad, yeah, and a really good friend, and then another student from the appellate clinic.
Okay, wonderful. So, yeah, absolutely. So, congratulations on your first argument here. Dad, congratulations on your daughter being in law school and arguing. Did you travel to come here today? So he lives in Cincinnati?
We live in Hamilton, but we're here all the time.
Oh, okay, so it wasn't that much of a trip for you?
Yeah.
Okay, very good, very good. All right, well, we're going to conclude the proceedings in a second, but before we conclude the proceedings, would you like a few minutes, and we're happy to take our robes off and step down for a few minutes if you like, with the students and with our guest who has traveled across oceans to come here today. If you have a few minutes, and if not, if you need to move on, that's fine also. Do you have a few minutes? Okay, so we're going to conclude the proceedings. Thank you so much, Karen, for your patience. And we're going to come back in a few minutes, all right?
All right. Court of Appeals First Appellate District of Ohio is now adjourned.
Are we not on road?
Yeah.